Good evening, friends. My name is Vishal. Welcome you all to StudyIQ IAS English. Students, in today's video, we're going to discuss a strange incident that occurred yesterday in the premises of Supreme Court. Yesterday, approximately at 11:35 a.m., an incident occurred that has received negative publicity, especially in Indian media. In Supreme Court, yesterday, proceedings were being conducted like any normal day. Students, I would like to inform you that in any High Court or Supreme Court, the court number 1 is always reserved for the Chief Justices. That means in any High Court, court number 1 will always be reserved for the Chief Justice of that particular High Court, and in court number 1 in Supreme Court, it would always be reserved for the Chief Justice of Supreme Court. The proceedings were being conducted, and a senior advocate by the name of Rakesh Kishore, who he tried to approach the podium of the Supreme Court. He tried to approach the podium. He took off his shoe and tried to hurl the shoe at the Chief Justice of India, B.R. Gavai, who was conducted legal proceedings. Now, this was a strange incident because till now in the history of independent India, we have not witnessed any such event, let alone Supreme Court or High Court. Not even in any district court in this country, any person has tried to hurl a shoe at a sitting judge. Now, this was a strange incident. So, it led to commotion in the courtroom number 1, and rapidly the security guards that were employed in the security of the Supreme Court, they suddenly came in. They took the advocate out of the courtroom, and the proceedings went as they were going. Now, students, this incident has received negative publicity among the media. People are questioning the conduct of an advocate who was 71 years old. Mind you, he was not a young candidate. He was not a young advocate. He was an advocate. He must be familiar with the courtroom ethics. He must be familiar with the professional ethics and the professional conduct that an advocate is bound to follow in his courtroom. Now, students, people are questioning what compelled this particular advocate to do this particular act, and what is the punishment that can be meted out to this particular advocate because he has done contempt of court. After that, he also committed professional misconduct, because advocates, being the law officers of the court, they are supposed to conduct themselves in a manner that is befitting of an advocate. And an advocate is a person who always helps the court to reach justice. So that means an advocate is expected to conduct himself in such a manner that be befitting of a person who is a law officer. The students, in today's class, we're going to discuss what kind of punishment can be given to a person who tries to commit any act like this against a judge of a Supreme Court or High Court or even district court for that matter. And if that person happens to be an advocate, what action can be taken against that particular person? See, during routine proceedings in Supreme Court, an advocate, 71-year-old advocate, Rakesh Kishore, tried to throw a shoe at the Chief Justice of India. Obviously, he was dragged out of the court, but mind you, while he was getting dragged out of the court, he just tried to scream, and he raised a slogan. The slogan was, he shouted in Hindi, Sanatan ka apman nahi sahenge. That means, we will not tolerate the insult of Sanatan Dharma. Now, obviously, when the incident occurred, and acting in a very rapid manner, the Bar Council of India, we all know that in India, the legal profession is regulated by Bar Council of India. In India, the legal profession is regulated by Bar Council of India through Advocates Act 1961. Likewise, as if in this country, the medical profession, it is regulated by the National Medical Commission. In the same manner, in this country, the code of ethics, the code of professional conduct, the disciplinary proceedings, all are being regulated by the Bar Council of India with respect to the advocates. So, immediately acting on this particular news event, the Bar Council of India suspended the advocate with immediate effect. Now, what do we mean by suspension? Suspension generally means now he will not be able to practice before any court of law, even tribunal in this country, till the time his suspension is revoked. That means from now onwards, until the time his suspension is revoked, he will not be able to, the advocate will not be able to practice before any court of law. Now, students, as I've discussed, the advocate, the guilty advocate, he was 71 years old. He is 71 years old. That means he is not a novice. He is a senior advocate. He must be acquainted with the courtroom ethics. He must be acquainted with the professional ethics and the code of conduct that an advocate is bound to follow. Then why did he take such an extreme step? So there is a reason that has been apparently considered to be the reason for which he took such an extreme step. So then what happened? What happened? Last week, a petition was filed before a Supreme Court. A petition was filed before a Supreme Court. Now, in this particular petition, the petitioner was praying for the restoration of an idol of Lord Vishnu in a temple in Khajuraho in Madhya Pradesh. So there is a temple in Khajuraho in Madhya Pradesh. It's an ancient temple, and due to occurrence of time, the idol has become damaged. Now he was trying to petition the Supreme Court to issue an order to appropriate authorities so that they can take out the restoration work and they can restore the idol. Now in this case, the petition was being heard by the Chief Justice of India. Now the CJI, while dismissing the petition, and obviously it is within the prerogative of the court to either accept or dismiss the petition on its merits. So obviously when a judge dismisses a petition, he is just doing his duty. The Chief Justice of India, CJI Gavai, he dismissed the petition, but while dismissing the petition, he made a remark, or we can say he passed the comment. Now the comment was, ask the Lord to do something. He said the petition was a publicity interest litigation, and you shall ask the deity himself. If you believe in the deity, if you believe in the Lord, you shall ask the Lord to do something and restore the idol. Now students, many people have taken this statement as offensive. People were just considering if CJI Gavai had to dismiss the petition, he could have dismissed the petition. But what was the need of passing these comments? And after that, CJI Gavai, he also issued a clarification that he did not want to insult any religion. He respect all the religion. But certain people, they were hurt by this statement. And as the statement made by the advocate, when he was taken out of the court, it also indicates that this advocate was also irritated by that particular statement, and out of that irritation, he took that extreme step. Now, as he was taken into the custody, and approximately after 3 hours, he was released. That means, till now, Supreme Court has not issued any contempt proceedings against this particular advocate. Now, students, we want to understand what can be done in this particular case. If Supreme Court want to initiate proceedings against this particular advocate, or if in future any other person tries to do any similar thing with the judges of the Supreme Court or High Court or even District Court, what can be done legally? Now for now, Supreme Court has refrained from initiating any proceedings against the guilty advocate. The Registrar General of Supreme Court has issued a clarification that they have not issued, and they have decided not to issue any legal proceedings in this present matter. But remind you, Bar Council of India, in its capacity, it has already suspended the advocate till further orders. An advocate has been given a time of 15 days to give a reply to a show cause notice that why he shall not be suspended for an extended period of time. Now students, now we'll talk about the law. Students, we all know that judiciary is a very important organ of a state. We all know it is the judiciary that holds the responsibility of enforcement of law in this country. We all know whenever a legal right of a person is violated, whenever a person suffers some crime, now it is the judicial organ of the state that comes to the rescue. I am aware that people in this country have multiple complaints against the judiciary. Biggest complaints being the judicial cases in India. The cases in India, they are dragged for a very long period of time. And we have always heard this phrase from people that in India, you will grow old and one day you will die, but you will not get justice. So people have seen cases where the person who was guilty, the accused person, when he was tried, he was 30 years of age, and when he was finally convicted, he was 70 or 75 years of age. And after that, the court said, as the person has become so old, now we cannot pass strict punishment against this person, because obviously the condition have changed. Now, students, in this country, people have complaints against judiciary. I'm not saying the judiciary is doing perfect job. I'm not at all saying that Indian judiciary is doing perfect job. Obviously, we have flaws in the system, and the flaws need to be fixed and mended. But still, it is an institution that delivers justice. If a crime happens with a person, obviously the person expects justice, and that too from judiciary. So that means judiciary in this country, it is an important institution. That's why the dignity of the judiciary shall always be maintained. I'm not saying that people shall not dissent from what judiciary says or the decision of the judiciary. You have all the rights. You have a right to dissent from the decision given by judiciary. You can have all the rights to even criticize the judgment given by the judges of the courts on merits without passing any personal comments on the conduct of the judges in the court. This right all of you have, even any person in this country have. But the thing here is, bitter, we also have to understand that institutions hold certain dignity. Institutions hold certain dignity, and the dignity need to be maintained. If people have complaints against judiciary, obviously they have to vent out their complaints and grievances. But this is not the way. This is not the way. Throwing shoe at someone, disrespecting someone in a court of law, and that too a person of a stature of Chief Justice of India, it is not an appropriate way. And even for a person, especially for a person who is an advocate himself, who understands that judiciary as an institution needs to be respected. So that's why, students, first of all, we have to understand that what is the law in this country? What is the law in this country that punishes advocates if ever they conduct professional misconduct, or if ever they commit professional misconduct in their behavior? So in India, we have an act by the name of Advocates Act of India 1961. Under the Advocates Act of India 1961, we have an institution which is called as Bar Council of India, and we also have state bar councils. So every state have respective state bar councils. Now what is the function of the state bar councils? The state bar councils, obviously they enrolls advocates, and after that, if a complaint of professional misconduct is filed against any advocate, if a complaint of professional misconduct is filed against any advocate under section 35, the disciplinary committee of the particular state bar council, it commits an inquiry. Obviously, it gives chance, it gives all the opportunities to the concerned advocate to present his case, and after inquiry, if the committee finds the advocate guilty, he can be either reprimanded, that means he can be either admonished by the committee. His license can also be suspended. His license can also be suspended by the court. That means his license can be suspended, and till the time his license is not reinstituted or restored, the person will not be able to practice before any court of law. And this has happened in the case of Mr. Rakesh Kishore. In extreme case, if the professional misconduct committed by the advocate was of a serious nature, so in that case, his name can also be removed from the state role of advocate. That means from now on, the lawyer will not be advocate. That means he will not be able to practice before any court of law, even tribunal in this country. Now we have to talk about one important provision in constitution, that is contempt of court. Contempt of court. Students, I've already told you, in this country, it is the judicial organ of the state that delivers justice to the people. We might have a complaints with the judiciary. You might not be happy with certain judgments that judiciary have given. It is perfectly fine. In a democracy, it is perfectly fine, and you have all the rights to hold your opinion even against the judgment given by the Supreme Court. But the dignity of the institution needs to be maintained. The dignity of the institution needs to be maintained. That's why in our constitution we have two important articles, and for the students who are preparing for UPSC CSE, these are important articles. That means they are a good thought, they are a good material for the purpose of examination. Article 129 and 215. Now what does Article 129 and 215 says? Both of them vest the courts with powers to punish for contempt. Article 129 in case of Supreme Court and Article 215 in case of High Court. They vest the respective courts with the power to punish any person for their contempt. For their contempt. Now, what do we understand by contempt? See, contempt generally means doing of any act that either lowers the authority of the court, scandalizes the court. Now, what do we understand by scandalizes? Scandalizes means obviously that attacks the authority of the court, or that impacts the administration of justice, that interferes with the administration of justice, or even disobeying the judgment or order given by a court. If you do not follow the order or direction or any judgment given by a court, obviously that is contempt, because obviously when you are disobeying the judgment of the court, you are lowering the authority of the court. Because in this country, people still have this belief that if they take their cases, if they take their grievances before the court, and if the court gives any judgment, if the court pronounces any judgment or order, so obviously all the people will follow. So this is the reason why people, rather than taking law into their hands, most of the people, rather than taking law into their own hands, they try to knock the doors of the court, because the court has this, the people have this confidence that in any case they will get justice from the court of law. That's why this dignity of the court, this reputation of the court has to be maintained. If any person try to tarnish the image of the court, try to lower the authority of the court, now the person has to be punished accordingly. And Article 129 and 215 of the Constitution, it allows the Supreme Court, it vests power in Supreme Court and High Court to punish any person who commit contempt of court, of either Supreme Court or High Court or even district courts. And this is a very important judgment, Om Prakash Jaiswal versus D.K. Mittal 2000. Now in this particular case, and if you are able to look at the content, what I have presented here, if you are able to look at the content of this particular case, or the judgment given by the court in this particular case, the court has in a very eloquent manner tried to explain the need for the power of contempt of court. Court has categorically stated, see, it is the binding nature of the command of the court and the respect for the orders of the court which deter the aggrieved person from taking the law into their own hands, because they are assured of an effective method of settlement of disputes being available to them through the medium of courts, wherein their grievances will be resolved. So the court has explained in a very eloquent way that what is the reason why courts shall have this power of contempt of court. Because court says people repose this confidence in the court that if something wrong happened with them, it is the court, it is the judicial organ of the state that will provide them justice. So people are assured, people are quite confident that they will get justice, no matter even delayed from the court of law. That's why people do not take law into their own hands. So if people start believing that they will not get justice, because now the authority of the court has become flimsy, now it will impel the people to take law into their own hands. This will create chaos. That's why the court said that any act that undermines the dignity of the court, it shall be punished strictly. Now students, what is the punishment? Now what is the contempt of court? I told you, under the Contempt of Court Act 1971, in India we have two kinds of contempt. One is civil and another is criminal. We have civil court contempt and we have criminal contempt. Now what do we understand by civil contempt and criminal contempt? Students, generally civil contempt means disobeying the order of the court. If a court has passed any particular order, it is a duty of the person against whom an order has been passed to follow that particular order or judgment, whatever is the case. Secondly, criminal contempt means when any person deliberately tried to lower the authority of the court. When any person deliberately tries to lower the authority of the court. If somebody publishes negative reports about the court and try to tarnish the image of the judges, that the judges are corrupt, they usually take bribes. Now in this case, the authority of the court, it is lowered. In the same manner, if any person interferes in the administration of justice, try to interfere in the administration of justice by his any act. If he try to approach judges to take bribe, if the person tries to manipulate the witnesses, all of them are interference in the administration of justice. So the concerned person can be punished with criminal contempt of court. So contempt can be of two types, civil and criminal, or both. Now what is the punishment? What is the punishment for the contempt? Generally, students, in case of contempt of court, a person can be punished with simple imprisonment. Imprisonment for a period of 6 months. Period of 6 months. The person can also be punished with a fine of 2000 rupees. But if a person issues an apology, unconditional apology, then in that case, the courts, while convicting a person, just release the person because he has understood his mistake. The person has understood his mistake and he has tendered apology, unconditional apology to the court. So that means if the person has understood his guilt, if a person is ready to mend himself, so in that case, the court usually does not award the punishment of imprisonment. And if contempt of court or any act that interferes in administration of justice, it is committed by an advocate. So in that case, apart from contempt of court, punishment for contempt of court, the advocate can also be punished under section 35 of the Advocates Act. I told you section 35 of the Advocates, it basically talks about disciplinary committee instituting proceedings against an advocate, continuing the proceedings, and after the proceedings, if the advocate is found guilty, so in that particular case, the advocate can either be suspended, or he can be admonished, or he can even, in case of serious misconduct, be removed as an advocate. That means from now onwards, he will not be able to practice before any court of law. So students, in this particular video, we have tried to understand the incident that occurred in Supreme Court, and it was a standalone incident. Such kind of incident has never occurred before any court in this country. Secondly, we have tried to understand if any person tried to commit any such incident again, what can be the punishment then can be imposed on that particular person. The person can either be punished under Contempt of Court Act, and if in case the person is advocate, he can also be punished under the relevant sections of Advocate Act. So with this, I'll wrap up the video and we'll meet again with a new video in which we'll discuss certain important topics or events that have taken place, and we'll try to connect them with your UPSC CSC syllabus. So that's all for today. Thank you.